All right, hey everybody, welcome back to Baltimore in 1833. I want to do a little bit of a thought experiment here for you, and let's just kind of see if you can check your expectations, your assumptions about the way that the Constitution works against what happened in this particular case. And in doing so, I want you to just think about putting yourself in the shoes of this specific person. There's a person here who lived in Baltimore in 1833, a real person, and you, this person, have a lucrative wharf in the inner harbors. Let's imagine, as early as the days of the Declaration of Independence, Baltimore was a very important city in the history of America, and actually, specifically like around Fells Point area. Fells Point was actually a really important part of sort of the infrastructure of the U.S. because a lot of shipbuilding happened there, a lot of trade happened there. This is even like an old lithograph, an old sort of quasi-photograph of some of what the city of Baltimore looked like a couple decades later. You can even see that there's this monument that's been erected, the very first Washington monument in the country. But so all that aside, you're this well-to-do sort of business person in Baltimore in 1833. You've got this wharf. And the way that this works is, so these ships come into the harbor, kind of like they do today. But again, the commerce was a really big deal here at the time. And you got paid, essentially, to allow ships access to use this wharf. So you're this sort of middleman, right? Where these ships come in, you've got a crew that helps them unload this stuff. However, and those of you like me who live in the city know that this is always something to be a little bit worried about. A work crew shows up with some papers from the city of Baltimore, embossed with this seal, and they say, hey, get out of our way. We've got orders, essentially, from the mayor to do some work. And lo and behold, what happens, they start digging up the stuff all around your wharf, all the cobblestones, all of the earth, and moving it around your wharf. And you can imagine, and you get quite upset about this kind of thing, right? And as they are digging up this dirt and gravel, it turns out they're actually scooping away a lot of the land that connects your wharf, right, the pylons of your wharf, to the mainland, right? So they're basically making your wharf no longer usable, essentially, by way of this construction project, which is essentially digging up all of the land around you. And so you might imagine you get upset, and like anyone would do in our extremely litigious, meaning legally sort of minded society, what do we do? It's more American than anything to sue the city of Baltimore. So imagine putting yourself in this person's shoes. Of course you want to sue. Of course you'd be mad that these people have made it impossible for you to conduct your business at this wharf where you've been making a lot of money over the last several years. And so let's imagine that you go to court in a Maryland court. Remember, we've talked about how at the beginning of sort of the U.S. context, these sort of state institutions are going to be the things that have the strongest influence on your life and the way that you're living it on a daily basis. And so in this Maryland court, you've hired a great lawyer with all your wharf money or whatever. And your lawyer invokes this Fifth Amendment to the U.S. Constitution, which of course was included in the Constitution, just a few decades earlier. And so, wait, you might remember the Fifth Amendment, right? The Fifth, right? I plead the Fifth, right? We've all seen, a Law and Order show or a Dave Chappelle sketch or something where somebody says, I plead the Fifth, right? Why would you use the Fifth Amendment in this case? Well, of course, we're probably all thinking about this first part of the Fifth Amendment, which says no person shall be held to answer for a crime without due process of law. It's called the Due Process Clause, essentially. And so the Amendment 5, the Fifth Amendment, pleading the fifth sort of circumstance, is essentially saying I'm not going to incriminate myself, right? However, there's some other stuff here in the Fifth Amendment. And so the Fifth Amendment also reads, no person shall be held to answer for a crime, nor shall they be deprived of life, liberty, or property without due process, nor shall private property be taken for public use without just compensation. So this is what's called the eminent domain clause. You might have heard this phrase eminent domain before, essentially. This idea that if the government is going to take your private property away from you, in this case, physically, like the land where you've got your business, they basically dug up your wharf, right? You can't take this away without providing you with the market value of that thing, right? The government needs to pay you back. And so what you might imagine, right, this is a pretty strong argument, right? This is part of the Constitution. That's one thing we want to really focus on, is the idea that just because this is an amendment to the Constitution doesn't mean that it's any less part of the whole, right? Just because we've added this on slightly later doesn't mean that this now doesn't become an actual piece of the text of our foundational document. And so this is just as much as, Articles 1, 2, 3, 4, right? Just as much as these original articles that were written by the framers, the Fifth Amendment is a piece of the whole that forms the backbone of our sort of legal system. And so directly quoting this bolded text here in a court of law, it seems like a pretty open and shut case, don't you think? And so you might imagine in this court, you actually win. And the just compensation part of the Fifth Amendment, right, is going to mean that it's just a cut and dry case. However, there's a catch. Okay, and this is a real case that happened. The city of Baltimore then appealed to the federal court system. Remember that federal court system that was established by Congress with the Supreme Court, which is outlined in Article 3 of the Constitution, right? So what happens is eventually this case goes through that federal court system that has been set up only a few decades prior by Congress, and eventually to that third great branch of the federal government, the Supreme Court. And eventually what happens is the Supreme Court overturns your ruling. So this is a landmark case you can read about called Barron versus Baltimore. It happened right here, right, just right at the Inner Harbor. This is one of the most famous cases in American legal history. And so what happened here was this guy, John Marshall, who's a really, really, really important name in the history of the court, who's actually somebody who's quite federalist by by nature, somebody who's one of, again, like the most important legal minds of the early American Republic. This sort of federalist guy has tried over many different court cases to interpret the Constitution in ways that help to strengthen and sort of further solidify the power of the federal government relative to all sorts of other powers, including the states. However, this is a different kind of decision that John Marshall is sort of writing here, in which in Barron versus Baltimore, John Marshall writes a really anti-federalist kind of decision. And in fact, this court case and the actual text of that case demonstrates this really important principle of constitutional interpretation. Let's read this together right now, and let's see if we can make heads or tails of it. And so I encourage you even to pause the slide, read this all the way through, and then let's talk about what it means. Okay, so pause the slide for just a second. By the way, sorry the vacuum is running upstairs if you can hear that. So let's pause the slide briefly. Okay, so John Marshall is saying here, each state established a constitution for itself, right? We were talking earlier about this idea that the U.S. does not have a single constitution. It has many constitutions. All 50 states have constitutions, right? And then the federal government, the Constitution of the United States has actually changed over time as it's been amended. So each state established a constitution, and in that constitution, those constitutions have restrictions on the powers of its particular governments. So what John Marshall here is saying is, look, right, we've got the Bill of Rights and stuff, which is part of the U.S. Constitution, but hey, what about the Maryland Constitution? The Constitution of the state of Maryland, all these really thoughtful Marylanders got together and they created their own constitution in Maryland. And surely, if they were thinking about the well-being of their citizens, then they would have written in a Fifth Amendment equivalent into their own constitution. And so what he's saying essentially is the Fifth Amendment is really about the federal government. It's the federal government's restrictions. It applies specifically to that top part of the layer. And the bottom layer of the cake of federalism, the states, they all have their own constitutions. And so the Bill of Rights essentially is really only applying when we think about issues that have to do with the federal government, not the state governments. The state governments, they're constrained by the rules in their own constitutions. And so if the Constitution of Maryland, circa 1833, had a clause saying, nor shall private property be taken for public use without just compensation, then yeah, Barron would probably win his case. However, in 1833, the Maryland Constitution had no such clause providing for just compensation for government taking your property. And so because it was the Maryland state government that had dug up his wharf, essentially the agents of the state were the Baltimore city workers. They're paid by the state. They work for the state as government workers for the city, right? Because that's a state level thing. John Marshall's saying, well, this thing, the Bill of Rights, that's really only applying if it's the federal government. So if the army came and dug up Barron's wharf, then John Marshall would have said in this case, well, surely this has something to do with the Fifth Amendment, because that's involving agents of the federal government, aka the U.S. Army. However, because again, this was a Maryland decision, it was a Maryland group of people that did this, it has no bearing on the life and lucrative wharf of Barron. So again, just to recap, in this case, in 1833, the argument was that states do not have to yield to the Bill of Rights. The Bill of Rights only applies to cases involving the federal government, and if there's no Fifth Amendment equivalent in the Maryland Constitution, sorry, the city workers are working for Maryland, not the federal government. These are apples and oranges, and therefore the Fifth Amendment does not apply. Wow, right? That seems really counterintuitive, because today, of course, that's not true. Right? Today, the city could not do this without having to follow the rules of the Fifth Amendment, right? And so the question that immediately springs to mind, hopefully for you, is how are these circumstances so different? How was it that in 1833 Barron got screwed, but today, if we lived, down, in Locust Point or whatever, and somebody like knocked down the back of our row house to put in a post office, right, we would be able to sue the government for damages. In order for this to be true, for this new sort of legal regime to be true, we need to go through this process that's called incorporation. Okay, incorporation is essentially the process by which the sort of constitutional principles in the federal Constitution were applied to cases involving states. And so again, this is really telling the story of how states at the beginning were really like the sort of single-celled organisms that had the most power and the most effect on people's day-to-day lives relative to the very weak and thin federal government at the top. And over time, the Supreme Court has interpreted through this process called incorporation that some of these constitutional principles do apply to the state level. And so essentially, in this early era, right, in the 1830s on through to the Civil War, right, we've got examples where this legal precedent gets created that's called dual citizenship. A dual citizenship essentially is this idea that you are a citizen of your state as much as you are a citizen of the United States. And so your state rules, that's really what matters. And so you can imagine, right, we're getting close to a crisis here in the US, a constitutional crisis essentially, because of the fact that there's no harmonization between the states on the pivotal issue of slavery, right? The idea being that at that time, the southern states, right, they had their own constitutions. They could write essentially slavery into their constitutions, and it would be perfectly legal, despite the fact that there are certain kinds of liberties guaranteed in the Bill of Rights, because there's no incorporation. And so, of course, this is not a history course. This is not a course about the Civil War. If you don't know about this, I encourage you to do some of your own research, right? But late 1850s, early 1860s, all of a sudden dual citizenship takes on an even more salient meaning because of this idea that these states actually secede. They leave the United States and they try to become their own country and try to create a confederation, right? The confederacy, essentially, of the South. That is a separate political institution. And so you can imagine, right, like in the Genovian case, secession is one way in which constitutional arrangements break down, in which some of the participants in a constitution say, sorry, we're taking our states and we're going to form a different constitution that declares us to be sort of not applicable to the kinds of federal rules that you're trying to pass, right? For example, the 13th Amendment, which overrules these state laws related to slavery. And so again, I'm fast forwarding hugely here, but after the Civil War is over and the North essentially puts down this insurrection and sort of demands that these southern states reintegrate into the constitutional union, right? Abraham Lincoln devises a plan called Reconstruction. So Reconstruction is, in my evaluation, perhaps the most important, the most pivotal moment in the history of the United States. This, even more so than the battles waged in the Civil War, I think is the moment that decides so much of the next, 100 plus, 150, 170 years of the United States. This is the moment that we really, really have to think about, because this is where the rules of the game change. This is what we call an opening, essentially, a constitutional opening, where Lincoln is able to lobby for different constitutional amendments. And again, we had the Bill of Rights very, very early, right, 1789. Now, suddenly in 1860, we have a few more amendments beyond a couple of, sort of minor ones that sort of shuffle some things around. in terms of some formal rules. In this case, we actually have the 13th Amendment and the 14th Amendment, some of these Reconstruction Amendments, as they're called, that have incredibly important consequences for both the relationship between the federal government and the state governments, and also the welfare, essentially, of African Americans and emancipated former slaves in the United States all across the board. And so the first, obviously, the 13th Amendment is incredibly important because of the abolition of slavery. But I want to focus in this case on the 14th Amendment because it's a little bit more complicated and something that is so important for our understanding of civil rights and liberties. And so the 14th Amendment, we're just going to see some examples of it in a little bit, some pieces of it. But one thing you have to remember is that the 14th Amendment is a very lofty document, a document that's written with this abolitionist spirit in mind, and an incredibly powerful statement of what it means to be an American citizen. For the first time, right? Sort of revising this dual citizenship model that we saw as early as like the Barron versus Baltimore case. However, though it's very lofty and though it's a part of the Constitution after the Civil War is over, Lincoln is assassinated and President Andrew Johnson takes over. And Andrew Johnson is somebody who is a sympathizer, essentially, to the Southern cause, and it has no interest in trying to bring the 14th Amendment into reality, essentially, for the Southern states. And so this is why. The 14th Amendment says, all persons born or naturalized in the United States are citizens of the United States and of the state wherein they reside, which, interestingly, we can see again that dual citizenship sort of language in this 14th Amendment. But it goes on further to clarify, essentially, the supremacy of federal government mandates about rights for the first time. And it says, no state shall make or enforce any law which shall abridge the privileges or immunities of citizens of the United States, nor shall any state deprive any person of life, liberty, or property without due process of law, nor deny to any person the equal protection of laws. And that last clause, I think, is the most important of all. This idea that you may not, as a state, discriminate in ways that mean that the laws applied to one person in a state are differently applied than to people in another part of the state, right? This idea that everyone who lives in a state needs to have these laws enforced equally, right? We have the equal protection of laws. There's no discriminatory legal practices that are constitutional as the 14th Amendment is ratified, okay? So, it's an incredibly bold statement, this equal protection clause, because it's really saying, look, states, right? No state shall make or enforce any law which denies to somebody the equal protection of law. So you cannot make discriminatory laws, essentially. And really for the first time, because the Constitution at the founding is virtually silent on this question. And so the 14th Amendment is actually what we might call a constitutional revolution. This is a new constitution, ultimately, that the United States is dealing with. The same way that you could imagine if we went back in the Genovian case and totally changed one of the clauses that we had created in class. It completely changes everything. Because, again, this becomes part of our core document. The Constitution, which the Supreme Court must look at as the basis for its interpretations, which all states must look at due to the Supremacy Clause as the most important document in the land. So what this does is this creates what we might call a de jure, or legally prescribed basis for full inclusion of not just of former slaves, obviously that's what the intention of the 14th Amendment is, but of everyone, right? This idea that laws are not allowed, state laws are not allowed to discriminate. Right? This gives a legal basis, which means that you could sue, essentially, or you could call this to the attention of federal courts if a state were to pass a discriminatory law, and potentially we would see that the federal government could act. However, I think the thing to remember is that this attempt to incorporate civil liberties and rights into the states through the creation of the 14th Amendment is not perfect. Right? It's not something that was just, hey, we did this, right? All of a sudden, automatically, like some sort of machine, the United States sort of just all changes in lockstep. Of course not, right? We can write rules down on a piece of paper, but it's up to the people who actually inhabit those institutions to follow them. And that's one of the things about a constitution that make it both incredibly optimistic, but also incredibly fragile, is that we need to value these rules as the rules and follow them in order for our constitutional system to work. And so what we saw in the South, and we saw in the South essentially throughout American history and in many other cases as well, across the states, was de facto discrimination, in which Southern states implemented all kinds of different discriminatory practices that circumvented and in many cases flatly went against the spirit of the 14th Amendment. And so the Supreme Court saw this happening, and they had to intervene in many ways. And they had to say, essentially, no, you can't do that, right? The Constitution expressly prevents you from doing this due to the Equal Protection Clause. And so one of the ways that the Supreme Court was able to act in order to help sort of stop this discriminatory set of practices was to utilize this power of incorporation. And so what they ended up doing, right, was they ended up taking new cases and saying, essentially, actually, the precedent, which said that we've got this dual model where states get to do their own thing and the federal government gets to do their thing, right? They overturn those rulings, and they issue new rulings in new cases which change the way that all lower courts behave on the basis of those rulings. And so incorporation is that. It's essentially this idea that over the span of American history, the Supreme Court has taken these cases and they've actually ruled on them in ways that say, hey, take Barron's case, for example. In CB&Q Railroad versus the city of Chicago, something very similar happened, where a railroad got messed up by Chicago, basically, and this railroad said, hey, you're interfering with our ability to make money. And the Supreme Court ultimately took this case, and they said, actually, city of Chicago, you do have to pay CB&Q Railroad restitution because the Fifth Amendment does actually apply to you. Using the 14th Amendment, using the clauses that are included there as essentially a legal like key that unlocks the lock that allows for the Fifth Amendment to apply to the states. And so all these things together mean that we are arriving at more robust guarantees for rights and liberties across time. However, right, I've got here a question, maybe you can ponder this one. When do you think the First Amendment, right, the all-important First Amendment about freedom of speech, when do you think that was incorporated to the states? Or the Second or the Fifth? I just want to leave you with this little table. You can see some of that in the textbook as well, but you can see essentially, you can read about these cases if you like, but many of the provisions in the Bill of Rights took until the 20th century, and in some cases the 21st century, to be incorporated into the level of the states. And so, again, I just want to really give you this notion that we as Americans who are living in the modern time, we are incredibly blessed to have had incorporation happen over the span of this long period. Meaning that beginning in the 19th century with extraordinarily discriminatory practices by states, over time successively courts have intervened and have made sure that these guarantees, which seem cut and dry in the Constitution, apply to the state level. So ponder this a little bit as we turn our attention now from this discussion of how the Bill of Rights came to become more important and impactful in individual people's lives in America, to a question of civil rights and some of the things, again, that the government may need to provide guarantees for in order for individuals to live more freely and more equally. So I'll see you all in the next video where we'll talk more directly about the long and slow and very difficult process of gaining civil rights.